All right. Welcome everyone to our event today. We're thrilled to have you out there. My name's Ryan Liss, and I'm a professor here at the University of Western Ontario, Faculty of Law. And I'm also one of the directors of our Public and Private International Law Research Group. And I'm extremely excited to welcome you all to this year's International Law and Global Justice lecture. The lecture is the research group's flagship event and the preeminent international law event at the university. And we're thrilled at how the lecture has grown over the last 5 years to become such a central aspect of academic life here. And it's always an extremely exciting opportunity for students and faculty and members of the broader community to engage with and hear from some of the leading thinkers in the world of international law. And in the 5 years of the lecture's history, we've really been lucky to hear from some of the foremost scholars and practitioners of international law. And this year truly is no exception. We're absolutely overjoyed to welcome David Kennedy to deliver our 5th International Law and Global Justice lecture. But to properly introduce David, I'm going to hand things over to my colleague, Nadia Lambeck, a professor here with me, to say a few words. So thank you all for joining.
Thank you, Ryan. It's really my distinct honor today to introduce David Kennedy, the Manly O. Hudson Professor of Law at Harvard Law School, to give this year's International Law and Global Justice lecture. For the last several decades, sorry if that's dating you, David, Professor Kennedy has been he's been a leading scholar of international law, bringing his critical insights to bear on the making and remaking of the international system, the development of global law and policy, and the intersections of law, political economy, power, and subordination in the world. His books, including The Dark Side of Virtue, Reassessing International Humanitarianism, A World of Struggle, How Power, Law, and Expertise Shape Global Political Economy, and his newest collaboration with Marty Koskiniemi of Law and the World, Critical Conversations on Power, History, and Political Economy, each challenge us to look anew at how the world and expertise and law works in practice, and to uncover and foreground the unintended consequences of legal projects on peoples and places in the world. I could very easily sing Professor Kennedy's accolades for many hours. He has written a truly remarkable number of things and contributed a remarkable number of insights. But since there are so many law students in the audience, I can see you all on the attendees list, I thought I would maybe end or conclude my introduction by commenting on Professor Kennedy's deep commitment to mentoring and training future generations of legal scholars. Through projects over the last few decades, like the New Approaches to International Law and the Institute for Global Law and Policy, Professor Kennedy has offered generations of scholars really around the whole world opportunities to learn together, to hone their craft, to think more deeply and critically, and to challenge their own thinking. Many of us on this faculty at Western, myself, Professor Gabramusi, Professor Kenne, we've all benefited over the years from his generosity and his probing intellect. And for those of us who have been lucky enough to engage with his scholarship or to work with him, he's really been an unbelievable mentor, shaping how we think and how we engage as scholars. Anything that I have left to say is not going to be as exciting as what David's going to present. We're all in for a real treat here. So I'm going to stop talking. Professor Kennedy is going to take about 40 minutes or so to speak, and then we'll have a Q&A. It's a bit of a challenge in the Zoom webinar format to do Q&A. So please just type your questions either into the Q&A function or into the chat function. And during the Q&A, either Ryan or I will read them out. Thank you again, David, for making the time, and take it away.
Great. Well, thank you so much. That was a really generous and kind introduction. Nadia, thank you. Ryan, for all your help in putting this all together. It's really an honor to be this year's International Law and Global Justice lecturer. I'm just sorry it's a webinar and we're not all together in a room somewhere, which would be lots more fun. But so let me just start with the lecture's name, International Law and Global Justice. I think that raises some crucial questions that are going to animate my remarks, and I hope will stimulate an interesting conversation afterwards. So 3 questions in particular. So first, is international law the right place to look if we want to understand something broader, legality in world affairs? How much does international law, as we've understood it, contribute to global legality more broadly? How do we fit it into that overall picture? And to figure that out, I'll need to talk a bit about all the other norms and procedures and arrangements that contribute to law's real ubiquity in today's world. And then secondly, wherever international law might be situated in this overall fabric, is it allied with justice? And what would you need to think that it is? Or a related question, is it oriented to solving the most pressing global problems? That's also sometimes said about international law. To figure that out, we'll need some sense for law's contribution also to injustice and its contribution to the problems that we hope it might also solve. So let me take those 2 points in turn, and then in probably the second half of my remarks, look at how this is played out in the interactions between law and war, given that we're very much bombarded now with news of at least 2 wars of the many that are raging on the planet. So to start off, we need a picture of global legality to be able to assess why we might and might not expect that it's closely allied with justice. So let me start with a really conventional picture, familiar from anybody who studies international law, in which the triangles are states. They have their own internal legal system, which has vertical public law and horizontal private law between parties. And then they relate to each other, sovereign to sovereign, generating international law. So international law is the law they make, and when they do, it rises above the line into the international arena, and everything else below is in the national arena, with the sovereign standing somewhat as a boundary between the two. Very, very familiar image of how this works. So what would we need to think that law defined, made, and enforced that way might be about justice? Well, so we could think that states reacting to the horrors of war committed themselves to a common vision of global justice. Something you hear pretty frequently. And I guess just put it on the table to ask how plausible that sounds as a kind of ongoing priority or project of all states, or the most important states, that somehow states would consistently enact, propose, structure, and adhere to law on that basis. Possible. Or we might think that there's a kind of natural historical evolution that is slowly civilizing the world's sovereign powers. One heard that a lot. I mean, one heard that in the late 19th century, a kind of idea that was shattered by World War I. But one heard it also at the end of the 20th century, that there was some kind of movement in world affairs and world history that slowly brought us from a period of being at each other's throats tooth and nail to being in a more civilized institutional framework. It wasn't that the states decided it, they found themselves living in a new historical reality. Possible, also possible. And then we could imagine, well, it's not history and it's not the states. There's some other crucial actors behind the states that bend the arc of history in the direction of justice. It could be the civilizing orientation of a hegemon. So you could have a really very, very honorable global leader. Let's just take the United States as an example, which organized the world on the basis of justice. It could be that it's not the hegemon, or not only, I mean, hegemons have their own projects, but the legal profession itself, as a kind of cosmopolitan group of people located in every country, work together to civilize their own military and their own statesmen in a kind of collective cosmopolitan project. Seems possible, although it's also true that most international lawyers in most countries have as their job largely the defense of their national interest in one or another way, if in legal language. That might soften the ways in which individual states present themselves on the global stage, but it's hard for me to imagine that that's a recipe for global justice particularly. But it could be, it's not states, and it's not the legal profession, it's not history, and it's not a hegemon, it's the progressive pressure of civil society, informed populations, particularly in democracies, and informed consumers, particularly in market societies, who pressure all these actors in the interests of global justice. That's also a possible thing, and all these things do happen at some moment. One would have to start thinking how powerful they were, what they were up against, in order to have some view, an assessment of how connected they were with justice overall. So now what I'd like to do is complexify the picture by adding other legalities that traverse the globe. So let's start where we were before. There are states. Let's put international organizations and institutions into the picture, but let's try to think, what are all the norms that are floating around out there, maybe beyond those that are the agreed norms between states we had in our first picture? Well, it's possible that there are kind of civilizational norms that everybody in humanity who's civilized agrees to, that are outside and beyond what any state would write down or put in a treaty, but are just the ethical baselines of a civilized world that stand in some way to constrain what states do automatically. This is the shocks the conscience of mankind idea. And those standards might themselves be responsible for global justice. And that's possible too, although the candidates to be in that box turn out to be things about which there's a great deal of disagreement in the world. I mean, it's often said that torture violates such a norm. And it is true that very few people, although some, say, I'm in favor of torture and think it's a wonderful thing. But it's also true that torture goes on everywhere around the world all the time, and all kinds of things that could be called torture go on everywhere. So one has to kind of take these claims a little bit with a skeptical eye. Then it might be that there are just ways of interacting for states which themselves are normative. So it's like diplomatic custom. It wouldn't actually be a law. It could just be the way states do stuff. And the kinds of norms you could deduce from that that would be relevant. Put that there. There could be norms that are deduced from the nature of society, the nature of law, the nature of sovereignty. It just goes in the nature of sovereignty that, whatever, self-determination, you can't beat up on somebody outside your territory, something like that. It doesn't need to be agreed directly between states in the way that we were describing in picture one, and then you could have what we talked about in the first slide. Well, how much law is accounted for by all those boxes compared to what's below the line of sovereignty in terms of legality with an international effect? You have all the states that try to assert their jurisdiction extraterritorially. US efforts and other countries' efforts to enforce sanctions across the world would be an example of that. But far more important would be the impact of various national laws outside the territory, even when not intended to have that impact. So the impact of low wage environments on wages in high wage environments. If there's a low wage and a low minimum wage, and trade is possible, that low wage will have an effect on wages in Canada or the United States and so forth. That turns out to be huge. If you're putting together a global value chain and you try to figure out who, where has the power to do what in relationship to the production, distribution, insuring, and so forth of goods in a global value chain, lots of different countries have their rules will have an extraterritorial factual effect on what you're doing. And then there's private rights that you need in order to have a global value chain, so that when you have a contract in one place, it's operable someplace else. And then there's national law at home that affects foreign players and foreign interests. Almost all the legality that matters in the world is below the line, actually, compared to the stuff that's above the line. And now we'd need to ask, as we did before, what would you need to think that all that legality was associated with global justice? Well, you could think that national law substitutes for the normative and enforcement limitations of international law. You could think that justice is the kind of thing that national law is much better at, has rigorous kinds of, I mean, you have many countries that have human rights or civil rights of a variety of kinds in their national constitutions. You have courts that are much more effective. It could be that global justice for transnational matters is really a matter of domestic law, not a matter of global law. You might actually think an important component of global justice is respect for private rights. If you thought global justice was the enforcement of private rights, there'd be a lot to say for it here in some way. It could be that the process that civilizes participants is not a process between states, but is a kind of deep state. It's not just the international lawyers, it's all the administrative apparatuses and internal institutions of states. So that how do Canada and the United States engage with one another as states? Yes, our State Department and your foreign ministry do, but far more of the action, the government-to-government action, happens between Michigan and Ontario and in thousands of other places. And the process of doing that might automatically sand off the edges of things that are unjust and orient how the Great Lakes pollution is handled in the direction of justice. There might be other possibilities here that one might think about. But before we go too much further, let me complexify the story in two more ways. First of all, let's add some other players so that it's not just states, but there are also non-governmental organizations, private organizations, corporations of a variety of kinds, and, well, let's say people, leading people. So who would that be? Bono, or somebody who's running around as a normative entrepreneur in some way. So all those people are also pulling at the strings of legality in lots of places, making rules that have an impact on people within their own organization and on people between organizations. When corporations force standards down a supply chain, they're in effect legislating. They're enacting for global affairs what we might think of as a kind of public power. And so we ought to put them on the chart as one of the lawmakers, not just when they lobby governments, but when they undertake their own affairs and put it together using private law or however they do it in a variety of different places. So we put all those actors there, and then we need to figure out which of those actors do we think would be justice oriented. And for the ones who are less justice oriented, what is the kind of power dynamic between the justice oriented ones and the non-justice oriented ones? how would the people you think might be responsible for justice define it? Are they going to define it in the same way? How are they going to pursue it? So it's a plural and diverse world. You could imagine that people in each of those kinds of institutions will say that what they're doing is pursuing justice, maybe pursuing problem solving, certainly exercising their legal entitlements. But when they say that, they probably also conflict a great deal about what they mean and so forth. And so actually power is going to turn out to matter. Who has it? And the relationships of power among these actors need to be taken into account when we start thinking about justice. So let me complexify things a little bit more. It looks like that. So now, oh my God, we have big states and small states, and we have big corporations and small corporations, and we have rock stars that are not evenly distributed around the world, and so forth. And then there are all kinds of bilateral relationships, some of them enacted in a legislative arrangement or a treaty arrangement, some of them not, some of them practices that occur between states or between corporations and so forth. And in this whole story, you end up having a variety of different people who are lawmakers and people who are law takers. And when we look at it this way, we can see that there are all kinds of people trying to do unjust things with a cacophony of claims that what they're doing is just. In a certain way, because justice is the currency of the realm in global legality. If you're pursuing a project, you want to articulate it as being in everybody's interest, not just in your interest. Or that you're solving a global problem, not just that you're getting what you want. Because problem solving is also part of the currency of global legality. So what we end up with is a very confusing picture in which all kinds of people pursuing their individual projects are making assertions that what they're doing is promoting global justice and global problem solving, which leads me kind of to an alternative sense of how things fit together. An image of the global legality generally, less as global order and more as a terrain of struggle among all these people, where individual actors have little backpacks of legal entitlements and they go at each other, making claims and assertions about justice and problem solving and entitlement, all of which claims that they make strategically. People assert their interests by saying, shared values, man, or by saying it's really practical to do it my way. But the starting point for all those conversations would be unequal power across every axis of engagement, with actually nobody having the job of being responsible for what we might call the global public interest. So that's the kind of world in which we need to understand that we're operating when we ask whether international law is associated with global justice. Thinking about it this way has a number of advantages. It puts hierarchy, distribution, questions of authority at the center of the story. It doesn't start with the idea that there's orderliness or that there's equality. It starts with the idea that there's hierarchy and that there's difference. So rather than thinking first of trade as bargain for exchange, or as states as in a world of equal sovereigns, we'd rather imagine that in both domains, there's an overwhelming inequality in bargaining power. This also makes it easier to think in political economic terms, rather than in some more normative way, and aligns our analytic posture more closely with how actors themselves think about what they're doing. So I think very little of what I've said so far would come as a surprise to corporations, to states, to diplomats who know that they're making and hearing legal assertions strategically. And if that's how they think about things, then we as analysts observing the situation should also. So that's what I have to say at the general level. But given the ongoing wars in Europe and the Middle East, I thought I might use warfare as a kind of case study to evaluate the relationship between international law and justice. It's very common to imagine war as violence that law comes to constrain, to picture law as an instrument of peace, a humanitarian limit on law's violence. It kind of makes it really a test case for what I've been talking about. It's also easy to see that law is understood everywhere as a vehicle for the peaceful settlement of what are thought of as disputes. So I've actually thought the word dispute was a rather benign term for the kind of thing that gets people motivated to kill and risk being killed. But anyway, it says something about law's promise. It turns out, though, that war is not unrestrained violence waiting for law to contain its fury. It's always already, in some sense, a legal institution and a legal project. Law is part of what people fight with and fight for, just as coercion is part of how law operates. After all, people also go to war in the name of law, vindicating their entitlements or positioning themselves as the avenging arm of global legality. So in lots of ways, modern war is a legal institution. The battle space is as legally regulated as the rest of modern life. Not everybody follows the rules or even agrees on what they are, but war has everywhere become a professional practice, the only way to really manage thousands of soldiers and so forth, miles from base. It also turns out to be the only way to manage and discipline an insurgent force and keep, in some way, a handle on what people are doing. So it's, in another way, I suppose you could say war also occurs on a legal as well as a physical terrain. People say war is something that's made on a map, but there's also a legal map. So where does NATO begin and end? How different is it to attack a member of the EU from a member of NATO and so forth? But finally, and with the most focus on international law, in war, different rules apply. To shoot a man or a woman on the battlefield is not murder. If you kill this way and not that way, here and not there, these people and not those people, what you do is legally privileged. And behind those rules are the general principles about which we've heard so much. The use of force must be necessary, proportional, and so forth. The civilian deaths must truly be collateral. Well, you can immediately see that marking these lines will be strategically significant. Less about getting it right than about talking for folks into finding the line where you want them to find it. Being seen to follow these rules will distinguish us, for example, from our enemies. Their tactics are perfidious. Ours reflect the principles of a universal or nearly so civilization. But there's lots of room for interpretation, and the terms for drawing these distinctions change a lot over time and have changed. The vocabulary may be more or less sodden with ethical considerations, more or less rooted in specific treaty arrangements entered into by states. The distinctions may be drawn more or less sharply, and so on. As a result, distinguishing war from peace is really pretty complex. And that's why I think military leaders and humanitarian outsiders become obsessed over the rules of engagement. Who can do what, to whom? The answers enable allies to establish a common front, enable families and soldiers to feel proud of what they've been doing, and enable soldiers to be disciplined to focus on the military objective and to attend to strategic perceptions of the violence they will cause. That's why everybody makes arguments for the legality of their military activity. Russia does, Ukraine does, the US does, Israel does, Palestine and its allies do. Just think of the ICJ hearings of the last couple of weeks. So if war is like that, what is law like in this world? I mean, first of all, we need to say warfare obviously implicates all kinds of legal norms, the whole stack that I had in the earlier slide. Administrative law, private law, land use, religious expression, finance, payment systems, government budgeting, conflict of laws. It's all there in the background if you're an attorney who's working in one or another way with military affairs. But let's stick to international law for a second, which is our primary topic. It turns out that international law about war is surprisingly fluid and doesn't really speak clearly or with a single voice. And there's a history to this. So if we start 200 years ago, international law was rooted in ethics and sensible policy. To think about the law of war was to meditate on the considerations of right reason and natural justice, to think about wise rulership. By the end of the 19th century, international lawyers thought that was all too squishy. We needed a more robust, formal law about war. Formal rules delinked from morality, rooted in sovereign will and clearly agreed to and written down. The goal was a framework of sharp distinctions, which could be elaborated by trained jurists independently of ethics and independently of subjective political judgment. That's what got you all the Hague Conventions at the end of the last century. Now, initially, both humanitarian and military voices supported these sharp distinctions, legally separating war and peace, identifying a distinct battlefield with distinctive combatants governed by alternative rules, seemed to both groups to make a lot of sense. Soon, though, both groups began to doubt whether such sharp distinctions really worked well, and they both came to want something less formal and more plural for different reasons. It's easy to kind of understand how they got there. For the military professional, bright lines can sometimes be helpful, but it's also appealing to work with broad principles, to weigh and balance the consequences of military action in light of their objectives, to assess military operations by their effects rather than by their adherence to narrow rules. For the humanitarian, on the other hand, doubt about the formal distinctiveness of war and peace often begins with the recognition that moral clarity often calls forth violence and justifies warfare. Military campaigns today are almost always launched for some putative humanitarian purpose. But more crucially, ethical absolutes can focus attention from a humanitarian point of view in the wrong place. It's not clear in advance which weapon or tactic will cause the least death. Rule against the use of chemical weapons, for example, on the battlefield seems to preclude the use of tear gas, but it precludes the use of tear gas that's routinely used in domestic policing, which means that if you're an American soldier in Afghanistan and you want to clear a cave, you don't have the tear gas you'd have if you were policing the streets of Boston. You have a flamethrower. So that kind of problem led humanitarian voices to say we need to focus in some other way on the kinds of activities that are most, whoops, I lost my whole thing here, that are most likely going to bring about ethical harm. We need principles. And so from both sides, you got the principles that we've heard so much about. The means of war are not unlimited. Each use of force must be necessary. Those things have become kind of ethical baselines constantly invoked by both the military and by the humanitarians who try to constrain the military. They're speaking the same language. In fact, it's kind of interesting. One of the things I've noticed is that human rights organizations in Washington and New York, when they're seeking people to assess targeting in a military campaign, whether it's in Israel, Palestine, or elsewhere, they tend to hire people who had the same job in the military assessing targeting, and the same people play the role on both sides of the house. At the same time, the sharp distinction between war and peace was itself softened, and the status of neutrality was abandoned in some way. The UN Charter replaces the word war with more nuanced and vague terms like intervention, threats to the peace, use of armed force, things like that trigger different institutional responses. But of course, once you have instead of war, self-defense, hostilities, the use of force, resort to arms, police action, special military operation, it becomes hard to keep it all straight and figure out which rules apply where. Now, all this didn't happen in a vacuum. It was part of the widespread loss of faith in the formal distinctions of 19th century legal thought, in the wisdom, as well as the plausibility, of separating law sharply from politics, or private right sharply from public power. So that's how it seems now. Where does that leave us in the current situation? Well, first of all, none of these vernaculars has disappeared. In this century, international law speaks about warfare as a matter of justice and wise policy, borrowed from the 17th and 18th century, as an object of 19th century juristic assessment through rumination on first principles and elaborated rules, and as a 20th century political struggle whose legitimacy can be asserted and reinforced by a very pliable vernacular. But that's not all. At the same time, the field also developed a series of very powerful antidotes to each of these three styles of reasoning. People will disagree about ethics and justice. Indeed, they often go to war over those disagreements, and it's hard to see that lawyers would be particularly good at knowing who was right about these matters. The agreed rules that followed the use of ethics were too narrow, principles too ambiguous, and so forth. And each use of the contemporary vocabulary is understood to be used strategically. Hard in that sense to take seriously from an ethical point of view. As a result, we might better think of international law as a set of arguments and counter-arguments, making and unmaking distinctions in a legal vernacular that's elastic enough to enable all kinds of diverse interpretations. Well, as we did before, let's try to figure out what that's got to do with global justice. So it's easy to understand the virtues of a powerful legal vocabulary that's shared by elites for judging the violence of warfare. So when things go well, law can provide a framework for talking across cultures about justice and so forth. More often, though, I think the partnership of war and law leaves everybody thinking their cause is just, and nobody feeling responsible for the deaths and suffering of war, all of which can be understood to be collateral or necessary or proportional. International law, international criminal law in particular, does promise both accountability and deterrence. But are those promises realistic? Or is criminalization an obstacle to peace in many cases, and a legitimating cover for most of the rest of war's violence? At the same time, good legal arguments can make people, citizens and soldiers alike, lose their moral compass and sense of responsibility in war. We need to remember, after all, what it means to say that compliance with international law legitimates. It means, of course, that killing, maiming, humiliating, and wounding people is legally privileged, permitted, and justified. Now, one time, a long time ago, I traveled to Senegal with the US Naval Justice School to train members of the Senegalese military in the law of war and human rights. Respect for law, we insisted, will make your military more effective, something you can sustain and proudly stand behind. But there was something chilling there. What does it mean to build a culture of violence that one can proudly stand behind? And it's here that I think we can begin to see the darker side of modern war and modern law, the loss of critical distance on the violence of warfare. It's easy, for example, to substitute argument about the UN Charter for ethical or political judgment about the consequences of war, not whether it's a good thing or a bad thing, but whether it's legal. But it's hard to think of a use of force that could not be legitimated by the Charter. There's almost always something to be said. The province is ours, our rights have been violated, the enemy is not in fact a state, we were invited in to help, they were about to attack us, we're doing this in pursuit of the principles and purposes of the UN, something. But I think more deeply disturbing at the individual level is the pragmatic assessment of wartime violence in legal terms. So let me take civilian casualties with a couple of examples from the American war in Iraq. It's easier for me to talk about my own country's experience than more recent ones where other armies have been involved. Of course, civilians are going to be killed in war. And the question is how one thinks about that. So if we go back to Iraq, U.S. General James Mattis, who later became our Secretary of Defense, was poised to invade the city of Fallujah, and he concluded his demand the night before that the insurgents stand down with these words that I feel like I've heard them again recently. Quote, "We will always be humanitarian in all of our efforts. We will fight the enemy on our terms. May God help them when we're done with them." Well, that's pretty chilling, you know? I mean, particularly when the law of armed conflict is so often a vocabulary used by the rich to judge the poor. Of course, the Iraqi insurgent, who was quoted in the same place on the same night, threatened to decapitate civilian hostages if the coalition forces didn't withdraw. Of course, he was also threatening innocent civilian death. Less of it, actually, than General Mattis was threatening, but without any humanitarian promise. That was also pretty chilling. In the conflict between those two forces, perfidious attacks on the American military, from mosques by insurgents dressing up as civilians or using human shields, were interpreted by many as reasonable responses to a massively outgunned but legitimate force with a legitimate project of insurgency and resistance. Indeed, one of the things that was striking is that even America's own troops typically responded in at least two ways. In the first, they would say, it's all perfidy. The insurgents are barely recognizable as human. They understand only force. But we also found a common recognition that, as one soldier put it, and I quote, "What would I do if this were my town? How would I fight? Probably doing just what they're doing now." Now, it's in that atmosphere that discipline is broken down in every asymmetric struggle, when neither clear rules nor broad standards of judgment seem adequate to moor one's ethical sense of responsibility and empowerment. Soldiers, civilians, media commentators, politicians all begin to lose their ethical moorings as the law in war becomes a matter of balancing, pragmatic calculation, and standards. A quick example to close. In the early days of the Iraq War, there was a guy, a Corporal Michael McIntosh was his name, and he reported that he and a colleague had declined several times to shoot soldiers in fear of harming civilians. It's a judgment call, he said. If the risks outweigh the losses, then you don't take the shot. So he's applying humanitarian law. And he offered an example. There was one Iraqi soldier and 25 women and children, and I didn't take the shot. But then the reporter turned to his colleague, Sergeant Eric Strumpf, who chipped in to describe facing one soldier among 2 or 3 civilians, opening fire and killing the civilians. "We dropped a few civilians, but what do you do? I'm sorry, the chick was in the way." So, okay, there's no avoiding decisions of this type in warfare. The difficulty, in my view, arises when humanitarian law transforms decisions about whom to kill into judgments, when it encourages us to think the chick's death resulted not from an exercise of human freedom, for which a moral being is responsible, but rather from the abstract operation of professional principles. What does it mean to pretend these decisions are principled judgments? It can mean a loss of the experience of responsibility at the command level, ethical responsibility, political responsibility. Indeed, the greatest threat posed by the merger of law and war is this loss of the human experience of moral jeopardy in the face of death, mutilations, and all the other horrors that go with warfare. So let me end then with a plea to recapture the politics and the ethics of war, to experience the weight of the decision to kill or let live. Most professionals flee from this experience. Most citizens do too. We all yearn for the resurgence of an external judgment, for political leaders, clergy, lawyers, and others to tell us that what we've gotten up to is in fact an ethically responsible national politics. And law helps us to feel that way. But should we? I look forward to the conversation.